Okay, I call this meeting to order. Roll.
Haugen.
Here.
William.
Here.
Monahan.
Here.
Johnson.
Here.
Nelson.
Here.
Biergard.
Here.
The mayor is excusing himself tonight due to the presentation of the recall petition under new business.
Okay. Are there any additions to the agenda? Okay, do I have a motion to approve tonight's agenda?
So moved.
By Scott, second. By Bill. All in favor?
Aye.
Steve. I'll vote aye. Okay. Need a motion to approve the regular meeting minutes from 11:03. Motion. By Bill,
Second.
by Scott. I'll just do roll call on this one. Mark?
Yeah.
Brian?
Yep.
Brad? Bill? Yes. Scott?
Yes.
Yes. Okay, let's go right down to new business. Let's go to review city council motion on September 15th regarding the use of video audio recordings. Teresa.
Back in September, the city had discussed recording our city council minutes. We had decided to purchase video equipment to record them, and the motion from the council was to take those recordings and just archive them for city use. Since that time, we have had a couple requests for those videos, and we have found out from our city attorney that basically it's an open record and we need to provide them. Basically, anything within the city is an open record unless it falls under an exception under codified law. This doesn't fall under any of those exceptions, so if we're videotaping the meetings, then those tapes, when requested, need to be provided to whoever's requesting them. So I guess at this point, the city council, you can discuss this item again, see if you want to continue recording the meeting or stop recording them. Or the option is, we continue to record them. Do you want to just provide the recordings upon request? You want to, once again, post them, talk about posting them on the city website. If they do request having the video, the city can charge them a fee of whatever that cost would be to provide that. Basically, the files are too large to email electronically to anyone, so we would have to put them on a disk or a jump drive. We could charge for, that service to anybody that requests them, or we can put them on the city website. Karen did check with our website host, GovOffice, to see what that would entail. I guess I'll let her kind of speak to what you found out about that.
Yeah, a couple different options. One being we can post the actual video on our website. She says audio and video takes up a lot of storage. Our website comes with 1 gig of storage. That's what we pay for in our annual fee. She feels, and she doesn't know for sure because she doesn't know how big our files is, but she says I'm almost positive you have to increase your storage capabilities of your website. So to increase it by 2 gigs, an additional 2 gigs would be $250 per year. To go up 4 gigs would be $500 per year. So it's basically an extra $250 per year for 2 gigs of storage. The other option she suggested is creating a YouTube account and putting a link to our YouTube account on our website to then go to YouTube and the videos would all be there. Or she said you could actually put the YouTube link to each video on your website. Just a couple different ways to do it using YouTube. That's the option she suggested. So I didn't really search any further into anything, basic information for now.
Currently, we have a YouTube link through the Chamber of Commerce and the Development Corporation and promoting Hartford that Karen implemented. And I'd like to know how long did it take once I supplied those 3 links for you to put that on the web?
Not long at all. Just
I'll just make it known, as I did a couple months ago, that I think the YouTube link is a logical choice. It does not use gig, and up at any space, and Is, very accessible and not labor intensive.
So how does it work? You click on the link on our website and it takes you to the YouTube account?
Are you asking me?
Yeah, I'm asking you.
Okay. Which page is it? The home page?
It's right on the homepage.
It's right at the bottom of the home page. There are three different ones. One promotes residential, the other one promotes commercial, and the other one is just a kind of a montage of stuff about Hartford. So that's really about it. You just click on it like you would a web link or an email link, and it populates and plays for it.
And all of the videos, audio videos would be resident on that site then once you click on that link.
Yeah, I mean, you could pull them, you could archive them out, pull them out as, after a certain amount of time, 6 months, 1 year, whatever, infinity. But that is, that's the discretion of this council probably.
Teresa, do you have a preference on how we would handle this?
I guess just for the sake of, cost efficiency, the YouTube, link sounds like it'd be the better way to go for the city versus paying for more gigabytes, for our website. I think either way, the time-wise, it's gonna be the same. We either upload it to our website or we upload it to a YouTube, so I don't think the time difference is just gonna be the cost difference.
I'll make a motion that we create a YouTube account and link to our website.
I'll second. With Brad, any discussion? Okay. Brian?
Yep.
Mark?
Yeah.
Scott?
Yes.
Brad? Yes. Bill?
Yes.
I'm yes. And we'll get that in place by tomorrow or sometime by the end of the week for this.
We'll work on it this week, yep.
Okay. Next, let's go to presentation of the recall petition.
The petitions were brought into our office last Tuesday, November 10th. And there were 314 total signatures obtained. I verified with the Minnehaha County Auditor's Office that they needed 275. And that's based on 15% of the registered voters as of the last general election, which was the November 2014 general election, and there was 1,834 registered voters. So of the 314 signatures they obtained, 31 were invalid, 5 were not registered to vote, 4 were not residents of Hartford, 6 omitted the county on their line, 1 had signed the petition twice, and 2 were dated after the petition was notarized and dated. And then 2 sheets were notarized incorrectly, so all of those entries had to be thrown out, which were 13. So that makes up the 31 invalids, leaving them with 286 valid signatures. So they are, and there's the recap.
I make a motion that we set the recall election for the first Tuesday in January. If I counted right, that's within the 20-day window, isn't it, Teresa?
Let's go look at the dates.
With your discretion, can I address the council?
Just we got a motion on the table right now, so I'm waiting for a second.
Okay.
Second.
And now you may approach there, Counselor.
Can I address the council?
Yes, you may, sir.
Pass this down.
Are
these all the same way, or is this one packet?
I wanted you to pass down, take one off and then pass down.
Oh,
the
yeah.
other. As it proceeds down, you get down, you should have a copy of 9/13/29 through 9/13/32, which is South Dakota law and recall petitions. You should have a copy of Attorney General opinion regarding the recall of the mayor of New Underwood, dated February 15th, 1983. And you should have a copy of the recall petition that was submitted to the city. I want to tell you first off about recall petitions and their legislative history. And the legislative history of recall petitions goes like this. Back in 1903, you could recall on the grounds of a general statement for the removal. In other words, you could state whatever reason you felt was appropriate. At that time, there was 15% of the entire number of voting electors were required to put it to a vote. In 1968, that was changed to be 25% of the registered voters. The last general election, it made it more difficult. And it said rather than a general statement, you had to have a specific statement. And after that change in 1979, you had the Attorney General's opinion, and that involved a recall petition for the mayor of the city of New Underwood. And the specific grounds were this: since his election to the post of mayor in May of 1982, Lynn Olaf has exhibited personality characteristics inconsistent with the office of mayor, and that Mr. Olaf has on a continuing basis harassed and intimidated residents of New Underwood contrary to the best interest of these residents and the community. The question submitted to the Attorney General was, do the grounds for the recall enumerated above satisfy the legal requirements for recall petition? The Attorney General said 9-1330 requires that it shall contain a specific statement of the grounds on which removal is sought. The conclusion is inescapable that the grounds relied upon in the New Underwood petition are general, not specific. It does not describe how or when that was accomplished. Such naked assertions simply do not satisfy the statutory requirement. The answer to question number one is no. Okay, it did not fit the requirements for a recall petition. After that, our legislature went on and it said that recall signatures on a petition were only good for 6 months. That was in 1983. In 1987, they changed it to 15% of those registered to vote was not 15% of those, or 25% that voted in the last election. In my opinion, that made it more difficult. And then in 1987, they added, in addition to the specific reasons, that you could only recall somebody for misconduct, malfeasance, nonfeasance, crimes in office, drunkenness, gross incompetency, corruption, theft, oppression, or gross partiality. And then they also, in 1997, changed the validity of the signature to 60 days rather than 60 months. So as you look at the petition that has been presented to you, I want you to keep in mind what the Attorney General has said as it relates to each of those grounds. And I've given you a copy of the petition, and I'd like to go through with you and ask some questions. And first off, it appears to be couched in terms of oppression, and it appears to be couched in terms of gross partiality. And I can tell you that I cannot find a specific definition of what oppression is for recall purposes in a municipal election. and I cannot find a definition of what gross partiality is. I'm telling you, our Supreme Court has never dealt with that specific issue, what those terms mean. But I can tell you some general background principles that might help you decide. But I think as you look at the petition, I think the first thing you have to decide is, are the allegations general or are they specific? Do they fit the specificity that the Attorney General said was necessary? If looking at allegation number 1, it says the mayor stated to attendees in a public meeting to show him respect, or they will be thrown out of the meeting without a hint of disrespect being shown. This does not tell us who it was said to, where the meeting occurred. Was it a public city council meeting? Was it a school board meeting? Was it at church? So the first question I want you to think about, does it state it with specificity? Second question is it factually supported? Is it true? Now, if the allegation were, and it's not the case here, but if the allegation were the mayor committed misconduct because he wore a swimming suit to a city council meeting and you were all there and he wasn't wearing a swimming suit, I would hope you would all say, well, that's not factually supported. That didn't occur. I'm not going down that path. Okay, so if it is specific and if it is factually supported, the third test to me is, was it oppressive? Number 1 again, was it oppressive? And the closest I can come is oppression as being something that is unreasonably burdensome, unjustly severe, rigorous, or harsh. Okay? If you get through the first two, that's what I come up with a definition, but it's not directly on point. I'm taking that out of other cases that just talk about the word oppression. The other definition is conduct that subjects a person to cruel and unjust hardship in conscious disregard of the person's rights. Okay? The second allegation that you have is that the mayor threatened a citizen at a public meeting that approached the podium to speak that he will be thrown out of the meeting if he did not sit down. And then it incorporates by reference a website, something on the internet that you're supposed to look at. And again, is it general or specific? Who was that citizen? When was that meeting? Does it contain a specific statement of the grounds as the Attorney General suggests that it should be? If you get that far, then is it factually correct? And of some importance here, and I can't get an answer to it, but it requires that you have a specific statement, and I can find nowhere that you can incorporate by reference the internet, what's on the internet, all right? And so I have visited with the Secretary of State's office, and my question was, can we do that? And I haven't gotten an answer that is satisfactory to me, whether you can or you cannot. Added to that mystery is the fact that I went and looked, or tried to look at it yesterday and today, and it is not there. And to be frank with you, I don't know how that works. Okay? The third allegation is that the mayor has recommended that videotape meetings not be made available to the public. And if I'm correct factually, there was a split vote on this, and folks decided some should, some shouldn't. It was 3-3, and I think the vote might have been a tie vote that the mayor broke. And first off, has he made that recommendation? Second off, is it specific enough? When did he do that? in accordance with the Attorney General's opinion. But if it is factually supported, was it something that was unreasonable, burdensome, unjustly severe, rigorous, or harsh, to constitute oppression? And then, for having voted and having an opinion, and those of you that voted with him or voted against the mayor, is that something that subjects you to recall because you cast the vote and someone didn't agree with the vote? Stated another way, does it rise to the level of oppression? Ultimately, you guys are gonna decide whether it does that. The next allegation is the mayor has consistently refused to allow citizens to address the council at open meetings. Who are those citizens? What meeting did it occur at? Does the allegation rise to the level that the Attorney General suggests that you need to have for specificity? Second test, are the allegations factually supported? And if they are, I think you should have someone say, well, where are they factually supported? And if they are, do they rise to the level of oppression? And I think we all would agree that the Pol Pot regime was oppressive. I think we'd all agree with what's going on, and some of the regimes around the world are oppressive. But ultimately, that's the decision you're going to make. The next allegation is the mayor refused to acknowledge the public interest in the EDD issue, which I'm assuming means the Economic Development Director issue, although it's not specified, and allow a change of venue, leaving over 50 people standing outside the public meeting. And you may recall, those of you that were at the meeting, that the number of people we could have in the room were checked. The fire department was consulted with, extra chairs were brought in, and there weren't enough chairs for everyone at the meeting, for all of them to be here. Now up in Pier, where I spent some time, we run out of places for people to sit, and they have to stand out in the hall if they're in their seats. If the governor's given his budget director his budget address, we stand outside and listen because we run out of spaces. But is it ever oppressive if a meeting isn't moved to accommodate the crowd? And you're gonna have to decide that if it was a refusal to move it unreasonably burdensome, harsh, unduly severe, rigorous, etc. The rest of the allegations deal with partiality, and I can't find a definition of the word partiality in Black's dictionary. I can find a definition of the word impartiality. I had to go to Webster's to find the definition of partiality. And the only South Dakota cases I can find talk about partiality in a judicial sense or a juror sense. And it comes up meaning bias, all right? But I want you to remember that it's not just bias, because Larry Nelson has a bias about the foods that he eats and about the candidates that he supports and about his religious beliefs. I have a bias and I can't check that at the door. But it says it has to be gross bias. And gross is a big, big, big word. Gross bias and gross, according to Black's Law Dictionary, is all out of measure, beyond allowance, flagrant. And so the first allegation on the mayor is that he proposed and initiated the elimination of the Economic Development Director without consulting any of the community bodies the Economic Development Director works with, or directs, illustrating his personal agenda when he took office. And again, remember the Attorney General opinion. We can't be general, we're supposed to be specific, but what were the community bodies that the economic development director works with or directs? Does that mean the chamber? Does that mean the Economic Development Corporation? Does that mean the Bike Trail Committee? Does that mean the Sports Complex Committee? Does it mean the school board? And if you have an opinion on something, well, first off, you guys gotta decide that you have to go consult with the world. The second thing is if you have an opinion, must you check your opinion, even if it's strongly felt at the door? And having an opinion is that grounds to recall you from, or at least hold an election to determine whether or not you're going to be recalled. I want to flip back and want you to think again about that legislative history I gave you, which we started out where it could be any reason, and then it had to be a specific reason, and then it was limited to those grounds. It started with misconduct and then all the way down to gross partiality. The second allegation is that the mayor used his official title in a letter sent to voters asking for a yes vote on the economic development. Well, actually, it's the EED referendum, not the EDD, but I'm just assuming that what was meant was the economic development direction. I'm told, but I don't know that some of you may also have signed a letter that my name is such and such, and I happen to be a city council. And you signed a letter. I think everybody agrees that the mayor did not put it on official stationery, did not use stamps from the city, did not use staff to do that. The mayor simply expressed his opinion. And you're gonna have to decide if that is something that subjects him to recall for gross partiality. The third allegation was despite overwhelming support for the EDD position, as was evidenced by the referendum vote, the mayor recommended to modify severely the duties of the EDD in the job description, disregarding input from the community task force and refusing to hear public input at the special meeting to review the job description. First question, is the allegation general or specific? Does it or does it not comply with what the Attorney General suggested to you? Second thing, does it describe how and when this occurred? Perhaps most importantly, is it factually supported? Now, I reviewed the tape on the Economic Development Director position where you were working off of a draft that came, I think, from the Economic Development Committee, or at least the committee, and there was a lot of discussion and a lot of input on that, and from that perspective, I ask you, is it factually supported? And then finally, did his recommendation on what we think we ought to do rise to the level of gross partiality? There's a statute that is 9-8-3, and this is the powers of the mayor and the aldermanic form of government. It says the mayor shall preside at the meetings of the council. And it says in part, the mayor shall recommend for their consideration such measures as he may deem expedient. Part of his job is to recommend to you as mayor things that he thinks ought to happen, that he deems expedient, that it is his opinion. As you consider whether or not him following his statutory duties, gross and partiality, you need to know that that's what his job is. And then the final allegation is the mayor declined numerous invitations to attend the public hearing on the EDD issue. The general or specific allegations tell us where that happened, how it happened, are the allegations factually correct? did his actions in saying, I don't wanna debate this at some meeting, I talked about it at the city council, did that rise to the level of gross partiality? Okay. Now, there's another statute that I want you just to be aware of because it has some bearing in my opinion. And you need to know there are two ways to remove somebody from office. One is the election process, if you move the petition forward. The second is under 317(6), where the Attorney General or the Governor or local Attorney General can file a complaint against a local governing official. And we go to court and the judge decides whether that person has committed any of the violations for removal. And they're exactly the same as the ones that are in recall. They are misconduct, malfeasance, nonfeasance, crimes in office, drunkenness, gross incompetency, corruption, theft, oppression, and gross partiality. And there's been one case that's been reported under that statute, and it was regarding a person named Peterson, who was a registered deed down, I think it was in Burke. And he had not been following the book about reporting the money that was supposed to be deposited, and it broke some rules, but hadn't stolen any money, or he just wasn't really doing that great a job. But the court in his case said removal of public officers from office is a drastic remedy. And statutory provisions prescribing the grounds for removal are strictly construed. Evidence in a removal action must be clear, satisfactory, and convincing. In dicta, the court said, just because you did something wrong doesn't mean grounds for ouster under the statute exist. The court also said that the defendant may have made some mistakes, or at times, in the opinion of others, may have exercised poor judgment, but an officer may make mistakes and still be absolutely honest. All right, with that background, it has to give the ground. Attorney General says that it has to be specific. You're gonna have to make a decision whether any of this conduct should subject you or anybody else, put your name in there, to a recall. And again, remind you that recall is a drastic remedy, and it has to be stated with particularity. Now, the statute says if a petition is presented, you're supposed to schedule an election. And I'm gonna tell you, the same language was present in New Underwood when that petition was presented, and the Attorney General said, not specific enough, he didn't state it specifically. With that background and food for thought, I'd be more than happy to answer any questions.
Counselor, I have two questions for you. The first is, for the 9 allegations, do we have to, with the criteria you provided, all 9 allegations have to meet that criteria, or do we just have to recognize that 1 or 2 just need to meet that criteria in order for it to be a valid petition?
The law says that it shall state the specific grounds for removal. My opinion would be that if they stated one ground and you felt that A, it occurred, B, it was factually supported, C, it fit the definition of conduct, then you could move forward.
And my last question for you, under 5.375, removal by recall, it states that the petition must demand the election of a successor to the mayor, commissioner, alderman, or trustee sought to be removed. Anywhere in this petition, did it demand that an election of a successor take place?
Would you give me a statute?
Sure,
That's not a statute. though.
That's not a statute, okay.
No, where did that come from, Teresa?
It came from the South Dakota Municipal League handbook. talking about. That's where that
Statutes
should
are
be.
cited, but
Yeah.
they're not specifically
Word
exact.
for
Some
word.
of them are pretty close, and others are not.
Okay.
And I guess one that I would like to point out is the second one from the other first page there, the second one from the bottom. It starts out by saying, within 10 days after the presentation of the petition of the governing body shall order and fix a date for holding a special election. That's not exactly what the statute says. It is the statute that's cited there, SDCL 91331. What 91331 says precisely is within 10 days after presentation of the petition pursuant to 91330. And 91330 sets out the requirements for a recall petition. So just to be clear, this is not a set of statutes. Statutes are cited here. What the threshold question we have to answer is whether in fact we do have a petition pursuant to 91330.
Councilman Bearden, did that answer your question?
Yes, that helps, thank you.
Any other one?
I have a question.
Yeah.
Where, I can understand the Attorney General's decision, where the Attorney General could pass judgment on the specificity of the charge. But I haven't seen anything brought in front of me that says my opinion on the specificity outweighs the signatures on the petition. Because you're talking opinion. You say it's the council's opinion whether it meets the threshold of specificity. And my argument would be that we all have different thresholds.
Okay.
Let's take drunkenness. Drunk in the park. Drunk in the park on this day. Drunk in the park on this day at this time. Drunk in the park on this day, this time, standing next to this tree. You know, there are so many different levels of specificity that I haven't seen anything that says a majority of this governing body's impression of specificity is what's going to determine whether this recall petition is accepted. The verbiage that's been placed in front of me is the same verbiage that's on the referendum election, and we never had this discussion. The verbiage what I read on this is the same as the verbiage on the referendum. And nobody talked about opinion about accepting that.
In answer to your question, if the allegation in the petition that the mayor should be recalled for misconduct because he wore a swimming suit to the meeting, I would suggest to you, when you decide whether or not to schedule that for election, the first question you would have is, number one, did that occur? Because if it didn't occur, I would suggest you probably shouldn't move forward with the election.
Can I stop you right there?
Yes, you may.
If the mayor wore a swimming suit to a meeting, and there were 314 citizens that felt oppressed by it, who is this governing body to say you weren't oppressed by it because we passed judgment on it?
In part answer to that, I want to give you the legislative history again. The legislative history is at one point in time, it could be for any reason, you just had to say it. And it went to, now you must state the specific reason. That's the New Underwood case. And then it went to, it must be specific grounds, and it must fit one of the definitions, misconduct to drunkenness, all the way to oppression. And if it doesn't fit the definition of oppression, it wasn't harsh, it wasn't unduly strict, even if you look at just the definition of oppression in Black's Law Dictionary, I think you need to think twice before you move it forward. Your point is, if I may finish, your point is that 315 people thought it was oppressive, and I don't have a choice.
But see, you're using your dictionary, and you can break the word oppression down to unfair. The definition of oppression can be broke down to unfair. So you have your opinion of that word, and I have my opinion of that word. You're getting yours out of a law book, I got mine off the internet. So, but that's more opinion. And what's getting lost in this is the signatures on the petition. Because I think 15% of the registered voters in this town is an incredibly high threshold. I think 60 days is a high threshold. So I have a hard time interjecting my opinion above the signatures on that petition, regardless of my opinion. If we get to the point where it goes to the state's attorney, and you know, I think 314 people would yield to the state's attorney. I would yield to the state's attorney. But, I mean, that's where I'm at.
I'm just telling you, the cases I've been able to find, giving you my opinion of what the statute says, told you what the Attorney General has said. Ultimately, you folks are gonna have to make a decision. I don't have.
Let me ask you one more question.
Yes, sir.
Hypothetical. If this governing body, because it's the opinion of some that this governing body pass opinion on whether these are specific enough charges to set a date and move forward. So this board, hypothetically, this board votes and passes it. Can the mayor veto it?
You know, I looked at that question, and if you look at the powers of the mayor to veto, one of the questions has been, when must he veto by? The second one is what I'm gonna call is or is there not a conflict? And if he has a conflict, perhaps he can't veto.
But I thought state law said there's no state law that says you have to abstain if you have a conflict of interest, is it?
Well, state law says that you're supposed to decide if you have a conflict of interest. And if you don't think you do, and the council does, 2/3 of them can tell you that they do. And then it also says there's a conflict of interest if you have a direct pecuniary interest. And I'm gonna tell you, without having researched it in great depth, I don't know that he can veto it.
But I don't know that we cannot set this date.
Let me ask you a question, Mark. You mentioned that the language in regard to the referendum is the same language, but this issue about specificity never came up. What language are you referring to?
As far as it being, the referendum petition shall be signed by at least 5% of the registered voters. Referendum petitions must be filed with the finance officer no later than closing hours of City Hall, City Hours House on the 20th day after publication of the ordinance and resolution to be referred. Upon presentation of a petition of referendum or initiative, the governing body shall submit the question to the electors in the next annual municipal election or the next general election, whichever is earlier. The governing body may, within 10 days of receiving the petition, order a special election to be held on a Tuesday not less than 30 days from the date of the order of the governing body.
So really, the only thing And just for my benefit, what is that, SDCL?
It's, 4.135,
For
4.140.
No, that's the
No.
municipal league
no.
number.
It's
Not
probably a
the
citation
SDCL
on it.
number.
It's probably under
12-1-18,
12-1-18.
12-1-16, 12-1-13, well, it's 13 through 16,
Well,
so that's all.
first off, you've got, your requirements there are that you have 5% of the voters' signatures. You gotta state what it is that you're referring, and, that's about it. But that's not what SDCL 9/13/30 says in regards to a removal or recall petition. That states very, very specifically that you've got, in addition to having 15%, you've got to state grounds that,